It's week one of the trial into the death of George Floyd, and his former girlfriend, Courtney Ross, was called to testify. Ross tells a story of how they met, their relationship, and their shared history of addiction to narcotics. Listen.
Floyd and I both suffered with an opioid addiction. Our story, it's a classic story of how many people get addicted to opioids. We both suffered from chronic pain. Mine was in my neck and his was in his back. We both had prescriptions, but after prescriptions that were filled and we got addicted and tried really hard to break that addiction many times. Addiction, in my opinion, is a lifelong struggle.
So she opened up about their use throughout the 3 years of their relationship and how they bought prescription and illegal drugs on and off. But according to Ross, Floyd began using around 2 weeks before his death. She even said she noticed a change in his behavior. So the question is, how important is this background information in the trial? Joining me now, criminal defense attorney and anchor at Law and Crime Network, Bob Bianchi. Bob, I know that you've been watching this trial very closely, minute by minute. We did have a conversation about it during the jury selection, and you originally said this was not a slam dunk case. Based on what you've heard this week, do you still have that same opinion?
Wow, that's a real tough one, Stephanie. Yes, I still say this is not a slam dunk case, but the prosecution is definitely scoring the major points in this case, especially yesterday's testimony and today's testimony from police officers, superiors within the department that are indicating that the knee on the neck was not a lawful policy, that he should not have done it. And once a person is under arrest and handcuffed, they should stop any kind of restraint, whether it's on the neck or not, and then put them in a side recovery position. It was damning testimony for Chauvin. Nevertheless, the juries don't like to convict cops. And to the point that he just brought out with respect to the girlfriend, I was surprised the prosecution called her as what they call a spark of life witness to talk about who George Floyd is, because she is talking about this addiction. She is talking about how his personality changed. And that is what the defense is trying to show this jury. And I think, and I've been saying, Stephanie, from the beginning of this, as a homicide prosecutor myself for many years, I'm worried about the juror of one, the juror of one. The one juror who sits there and says, you know what, drugs, was under the influence. There's witness testimony that he was incoherent at certain points in time. He's not following lawful orders of a police officer. I'm not convicting the cop. There could be, if I were a prosecutor, I would be worried for that juror of one.
Exactly. Well, and the defense, when you're talking about the knee on the neck, they were using the reason of crowd control and whether or not they were able to restrain him. So obviously, prosecutors are saying, well, he was restrained. There was not much more he could do. And at some point, obviously, he didn't have a heartbeat anymore. So do you think any of that is going to change the mind of the jurors?
Yeah, I think, first of all, the fact of the matter was the testimony is coming out that the officers never called for backup. So that whole thing about crowd control and worrying about the crowd is going to be a difficult argument for the defense to make. And also, it has come out that it's now 9 minutes or more, over 3 minutes. It could be 3 minutes and 51 seconds, which Mr. Floyd is not moving at all. That knee is still on that neck. And look, the visual of that video from all the hardened police officers I know, from the most conservative cops that I know, what I mean by that is those who don't have a problem putting hands on people. They look at that video and they're like, oh man, no bueno, not good.
When it comes to his issues with addiction and the girlfriend talking about how they would use narcotics and opioids and whatnot, does that matter? I mean, it sounds like he had some serious issues. And I believe in March, it looks like he had an overdose and he was hospitalized for several days, like 5 days.
Yeah, you hit what I think is Chauvin's only chance at a straight out acquittal, and that's cause and manner of death. That is disputed in this case. In all the homicide cases I've ever had in my career, I've never had the cause and manner of death disputed. And that goes to that overdose testimony that you're talking about. He had gone and was hospitalized for 5 days, froth coming out of his mouth, which is consistent with what occurred on the night of the incident with a former officer Chauvin, where that frothy substance is coming out of his mouth. Now, the defense lawyer in the opening statement said there was no injury to the trachea, there was no injury even externally to the neck, and that the cause of death was originally from the medical examiner. Stephanie, this is important. The medical examiner in that county said that this was from drug intoxication was the cause of death. The government didn't like that opinion and went out and got private MEs, medical examiners, to do the workup. And those people are going to come in and testify. It had to do with respect to the knee on the neck. But I'm sure a jury is going to sit there and say, wait a minute, are we cherry picking experts here? And what was the cause of death? And if they can't come to a conclusion beyond a reasonable doubt as to the cause and manner of death, that's an acquittal.
Yeah, so we have both sides using the same examiner's report trying to prove a different case here. And so as you were talking about, there's handwritten notes that said on the first couple of pages, if Floyd was found dead at home alone with no other apparent causes, this could be acceptable to call it an overdose. And then they go on to say, but I'm not saying that this killed him. And also there's other things that could be going on here. He had heart issues. And so they're saying that maybe the adrenaline of the arrest may have contributed to his death. And they were wondering like how much pressure of the knee was on the neck and whether that was actually the cause of death.
Yeah, I mean, I've been saying this all along. I mean, the look of it is not good. But when you're in a court, look, and I understand, it is not a good look. It is not a maneuver that police officers should be following or doing. But this is not what's going on here. And I'd be kind of surprised that some of my legal analyst colleagues of mine, who I respect greatly, who are very emotional about this. Derek Chauvin is a defendant now. He's entitled to the presumption of innocence, proof beyond the reasonable doubt to 12 jurors. And my question all along was, yeah, he's got his knee down there, but how much pressure was actually being exerted? What do we know about the mechanism of that injury, as we call it? And we really don't know much about it, other than the defense attorney opening up and saying in the opening statement that there was no external or internal injury in that area. That is a very important fact and circumstance. Then, Stephanie, just to get wonky with you, whether or not there's intervening causes or if it's a heart condition or a drug overdose, well, I have the jury charge right in front of me, what will be read to the jurors at the end of the case. And it's very heady stuff. It's really complex. And as a prosecutor, I don't like complex jury charges because that can create doubt in jurors' minds.
Yeah, it's kind of just unbelievable how this all started with a $20 fake bill, cops being called, and it's just incredible how it ended up with the death of George Floyd over a fake 20. I mean, that's where it started. And then we saw the videos of him resisting arrest, so then it just took things a step further. So I've had people ask me, like, is it worth arresting somebody over the $20 bill that was fake? And it wasn't like there's a narrative out there, and I know you're not here to talk about narratives, you're here to talk about facts in the case. But the narrative is like, you know, the racist cops and racist store owner, but like the store owners were minorities, and they kind of feel bad for calling the cops now over the 20. But at the end of the day, that's still like theft and fraud.
Yeah, it's very much like the Eric Gardner case, the death over a couple of Lucy cigarettes. You know, cops are in a difficult position, but you know, in my mind, they have to learn to de-escalate. This scenario did not have to get to where it was, but also they have to enforce the law and they have to make arrests as well. But you don't want to see anyone ever die over something like a $20 bill, a fraudulent $20 bill, or Lucy cigarettes. So, you know, I think that it's just a bad look. And again, putting the knee on someone's neck who's handcuffed and on their stomach, we all know about positional asphyxia. Cops are trained on it. It didn't require that level of force in that particular circumstance. So the arrest to me was fine. The level of force is problematic.
What did you make of the Minneapolis awarding the Floyd family $20 million before the trial? It seems like that was kind of a bad move. I know the jurors are supposed to, you know, not be reading the news and not following this and not have like an opinion either way. They're just supposed to sit in the trial and listen to the facts. But that might influence this trial, in my opinion.
Stephanie, if you had been watching the Law and Crime Network when that came out and I was hosting, I went berserk when I heard that. It is nothing less than trying to influence the jury. And I am really disturbed. Look, you could, whatever the civil case is, you want to settle the civil case. It could have been sealed. The whole case isn't even settled right now. It was a publicity stunt, and going out there in front of the cameras and allowing the civil attorneys to go out there in front of the cameras. I don't care if you're a prosecutor or a defense attorney. You should not be trying this case in the court of public opinion. It should be tried in a court of law. And Judge Cahill, who's a very even-keeled guy, originally said, this is no big deal, until they lost 2 jurors because they found out about it. The jurors making the understandable misassessment that if the city had paid that kind of money, then Chauvin must be guilty. So the judge was very agitated eventually about this. It's just not right. Let the guy have a fair trial. And I'm coming from a prosecutor's perspective when I say this. If I'm prosecuting Chauvin, I don't want this stuff going on outside of the courtroom, because pretrial publicity is already an issue that's been filed by the defense in this case. And if I get a conviction as a prosecutor, I don't want it being reversed because of antics like this.
Exactly. And it was $27 million, by the way. I said 20. So
That's
I just wanted to be factually correct here. Something else that I'm kind of concerned about is we have a lot of these media reporters that are just digging and trying to find information on these jurors. And I think it puts a lot of pressure on the jurors. So, but that's another topic for another day. Bob, we appreciate you breaking this all down for us. Thank you.
Thank you, Stephanie.
Coming up next, shocking.